me. Okay. First of all, हम अने फाकोलम बेनो में me थी record kura waha ka hem again eves before ko me kule ka danje jamis please feel free me ti fahung bar council ge aspiring lawyers foruming hama liben would have as well as the lecture slides. Then lecture slides are go tarn burnalam for the structure of the lecture thankole explain kola there nang me per my understanding, Al-Ustaz Ismail Visham has already conducted a very thorough tort lecture, and he has covered Rad Zega Mihatana me important cases. It's just for to avoid duplicity of effort. See the cases and Habadaka covered Quran, and I understand he's also covered nuisance. The tort of nuisance to a large degree, and around was covered Quran, and then furthermore, Arun Miti Hama highlight me Kolani because I know all of you must be Mihar with Samavara me working on your own to be studying for all of these modules as well that are upcoming in the bar exam. And हम फहा कोलम बेरनवन in case this farata kami khaneng ovedanati फहा कोलन Supreme Court के Justice Sood get website inanami justicesood.com again hama huriha publications that have been out so far get full text I think free kong hama huriha farata ka sexes kureven ove hemme tibe from by exam kiyawamun dairu me tort lawyer begotum west tort ke mihatana hori gaziyata explain koddi cover koddi for hunna hama tort law if this is available on the website, and just to make sure that you know where all the resources are available me kevamun devani then furtama kamakadan fa column bernu vikantata. So for this around border border focus column me bernumani rajega me tort law me develop with and the most important case, the most recent case is the Supreme Court ke me Fariwa Fire case Hussein Rashid versus Telco a case ka me if you have read through this by now hunna me har ware rit ko tort ke elements explain ko as well as mihatana rajega tort ke elements the cover kura they think case is a shahida case, high-fall construction case, and Ihsan versus state a cases the rajega mihatana huri elements that explain called different. So around AF focus call then I will touch very briefly upon some of the other torts that are included in your syllabus, such as defamation and vicarious liability as well. If you have any questions, you can type them in the chat or ahama me fahumvis around email call this among aspiring lawyers forum post call this around a fan and so I will be willing to respond to those. So if you have any questions, you can either ask them in chat or save them to the for the ending. And Miharu Fatalano presentation, unless there are any questions right now about how this will proceed. Okay, Arun Kuri again, Dana. Who had who have reference for NATO? Screen for NATO, who have reference?
Laba.
The Arun Furtham me Fatalani tort log Araf Kuda introduction Nakung tort loyaki Kochito Balaru Divahing tort Amikiani Madani go he Bunair Vare Safwans he Kamaki Huriha Tortaki Ves Madani ghost Namasuriha Madani go haki torterno a Madani ghost Kuga Ebahure equitable causes of action misal like unjust enrichment that the unjust enrichment arise again with some claim the consider kureve it's mihunani then contractual disputes a wes hama me madani go he adi etimi arne me namas tort ge action naka necha kunnan horizon wa enkamu on tort saki madani go he vs kuri ha madani go haki toreno ei saf kuran ei saf ko saf wanje henetse kuri ha befulna wes then me Arun Kurimis then me Meindi Hussein Rashid versus Telco Electric Company Limited ka MSF ko kiadeni ರಾಜ್ಯಗ ಟೋಟ್ ಮೆಣ್ಣಗ ಟೋಟಕಿ ಮದನಿ ಇಲ್ತಿಜಾಮ್ ತಕ್ಕೆ ಕಾನೂನ್ಗೆ ತೆರೆಗ ಹಿಮೆನೆ ಮದನಿ ಗೋಸ್ತ ಟೋಟ್ಗೆ ಜಿಮ್ಮಾ ನೋತ ಟೋಷಸ್ ಲಯಬಿಲಿಟಿ ಯಕಿ ದವಾ ಕುರಾ ಫರಾತುಗೆ ಮಚ್ಚ ದವಾ ಲಿಬೆ ಫರಾತು ಅದಾ ಕುರಂಜೆ ಕಾನೂನಿ ವಾಜಿಬ್ ಆ ಖಿಲಾಫುಮುಂ ಎಕಮುಗೆ ಮಚ್ಚ ಬಿನಾಕೊ ದವಾ ಲಿಬೆ ಫರಾತುಗೆ ಮಚ್ಚ ಕೋಟುಂ ಮತಿಕುರಾ ಕಾನೂನಿ ಜಿಮ್ಮಾ ಟೋಟ್ಗೆ ಜಿಮ್ಮಾ ಫುಲಂಜೆಹಣಿ ಕಾನೂನಿ ಮತಿಕೊಫಾವ ಮಸುಲೇತ ಖಿಲಾಫ ಅಮಲ್ ಕುರುಮುಂ ಟೋಟ್ಗೆ ಜಿಮ್ಮಾ ಖಿಲಾಫುಂಗೆ ಸಬಬುಂ ಎಹಂ ಫರಾತಕ ಲಿಬುನ್ ಗೆಲ್ಲುನ್ ದೆನಗತುಮ್ಗೆ ಗೆಲ್ಲುಮ್ಗೆ ದುರ್ಗಾಕ್ಕಮ ಬಲಂಜೆ ಅದಿ ಟೋಟ್ ಇಂ ಮತಿಕುರಾ ಕಾನೂನಿ ಜಿಮ್ಮಾ ಅದ ನುಕುಮ್ಗೆ ಸಬಬುನ್ ಲಿಬೆ ಗೆಲ್ಲುಮ್ಗೆ ಫರ್ವಾಗಿ ಗೊತ್ತು ನಗದೆವೆಣಿ unliquidated damages. So me bara short overview of the entire tort regime ehme me tort ke mi hunna tort ke min komme rukune no ta unsura furihama nuaha hindaku tort ke claim me ki successful one claim me no ehen etsa hilafa tort ke hure three elements that have to be proven etanong tort ke madata ki madkoje tort ke magandu rukun takaki ko batala me arun kurim mestane me hama Moldavian tort law for me available one in the link west PDF link west because the slides are available me link on access so then the slides are in front of me some access kureven then tort ke thing magandu element hengenda furtama e gaanuni gotum ada kurange wajibe mihege macha onna halat ka wajib khilafu e wajib radwani mihaka nuwata bayaka kamgavu adi e wajiba khilafum libe gaanuni farwa to ege enkamu mige mi inge kamaki mige innanje adi mi madkoje ad mindi me miharu tort madkoje me miharu tortious liability ge thing rukun kama nagaganave it's okay then adimiti explain koddi for me nani kuring tankole kuri kesakun e Ibrahim Latif versus Amanat Shahida me muli eti alugandu kiyade nothing but you can access these cases goves ade mega furtama etsa kamyonani fault engata fault ofa then innanjeni gellu then innani a fault a gelluma detereka causal linking innanse he kama ehme fault akam me vani kommeves kurimes bayan kurihen gaanunun emihege macha matikofawa wajibaka khilafu ehme gaanunun kommes interesting efarata gebeje he protect kuran adi e interest me protect kurairu me interest protect kurang sida statute ka vis inde dane nuata e statute ka inna it's a vidyam me fahun link meva breach of statutory duty ammi dani then gellum evvis farata ka misalakan arne me ihmal not negligence balanama ebeje employer provide kodden a safe workplace that the safe workplace provide koddevi for nonna halatege employee me unsafe workplace gossa misalaka balanyamun bimmatiga war boda feng hedi for me annani mi hun kassani den mitako notice half henne vesne then employee me duhum worker gossa efenuga kas efen hama kassala namas evis comment not evis there's no injury, there's no damage, there's nothing that has happened. That hisabun kon kamakatto tort kami dawa kureveni hem kurimes denevehen tort aki huriha element of satisfy again when we successful one claim and then each of these elements we will be looking at further in down the presentation ngeto then me the fahuba me tort ke tortung me damages naga de nego adi me ge be inde amdaniya vis gelung sorry maaf kareva for future economic loss vis me naga de be kama den ekam avis arundu kuin de nemen alsas visham ge lecture ge cover kod deva for waichi then tankole meharu me vara broad ko nagade vifahuri me conceptual hsvs this table tankole this table helps in making clear what this means misalaka tota ki jehun nota mara mari nota ege dashum mina jaha faana kamuge biru dekkum me assault and battery that to megen commerce aran kurimis tenne mehin protect kura interesting innan je nota rakka tere kureve maslahat ei hashikanduge hurumata amilasiyadat so then adi then goes hada miha kura amala vesinanse ei mihege huddane te mihege kaya allum nota mihege hashiganduge huruma kandalum adi hama evagutu jaha fan kamge biru dekko so min komme kama kives misalaka min komme kama kives waki tote eve mige ni tort aki aslu me tort law exists to protect the interests of people that are me ganun ge himene adi that does not incur kommehen criminal liability ehem bala iru me tort ka amugotegga huriha torts em mihunni kommes a primary interest protect kuran ei misalaka mihunna jehuma mara marige torts mihunni in the table the second column ga dakka fene hashgand ga huruma wata amilas yadat e interest protect kuran hama egota defamation nuata abura behuma balairu abura behum gaves in a primary eng interesting in the unlawful detention get tort gaves in a primary interesting in the namaves me negligence ki tankole tafat adi mihem buneve em popular it tort claim negligence ke me tort balairu negligence protect kodde ma broad ko huriha interesting him protect kodde almost huriha interesting negligence ka dashan khabave so egaves contrasting eba ade a negligence ehen kahala tort taka kive sama tafatu namas mi huriha tort take prove kurumugaves innane mi inna three elements a damage fault so fault damage adi causal link huriha totek gaves pernum vaise sure den adi vakim fahun negligence gaves sama hunnane torts hunnane elements ves hunnane kuriya davar ka fenna mundane then adi miga mihunani mi table ge ba fene ehen torts ves ei gair ganuni hayara minivan kan hifetuma asasi haggen nigula gatu maddi adi nafsani aniya furasara kurun aburabe mihen gos mi foi kialavima fernane rajya gabende mi fatu ke explain kod we for 27 different thoughts ingato maaf karwa 27 different thoughts akives hama bala ganata egotan full listing aning hing eves Varikang in any kernel island, even English is about 70 thoughts liavifa in the hang. And the egg elements are egg egg ing egotaka ves a hama final kong eves gotaka nimmerne kankamernon a thought mihunna interests ves me dunia badalwamung arnavaraka hama badalwan egotam misalaka cyber crime related thoughts vis bahure ehme thoughts ki abadues developing area of law engata ehme ekang mes handang koggen kuriya diyam exam among approach kuriyam hamarangalwane then midani negligence ki kocheta balairu negligence ki very simply put it is a remedy for those who suffer loss through the behavior of a person who fails to adhere to a legal duty to take reasonable care me anekka ves sama kuring dia huriha elements take mi hunnani then negligence e bunairu varang important distinction negligence in in the normal course of what misaka wahaka dakkala iru almen wara negligent kameke e kuri buna iru ei careless gotuga me maana kureveni to negligence amugote me beenun kura baha negligence in lawyer me mulin tafatu de bas me mulin tafatu gotuga beenun kureve de bas ehem balairu ehem negligence in loga ebahure hama prove kuranje kankande tami Hussein Rashid versus State Electric Company Private Limited anek fariva file case ka hama mi ebe inde tort ke terega himene ehmalumge amale ekkama beleni emalga asasi thing rukune furiham warame ei fault damage adi causal link ei ganunu matikura amalaka hilafumge amalu ganunu matikura amalaka hilafumge sababun ehem farataka gellun libun adi e gellun libifa wani e amaluge sababun kan dakka denevi sababi gulun min komme elementaka den balalana furtama mi onnani duty of care fault eme bunani mi har furtama non kiyal den mi ganunu matikura amala khilaf umge amalu ehen kama miti eba behavigen de ituru deechaka fault establish kuran furtama innam mi jeheni duty of care nuata ganunu matikura amale den eba innan jehe adi amala khilaf wefesmun a breach of duty of care ehen kamun mi thing rukun onner adi furtama rukun gayam kuruman eba jehe ituru dekamano e behavigen gosmi onani dekamaka ehen kamun balala beluma aslu hataru rukune bunummes rangalu kama alugande hive a duty of care breach of duty of care damage adi causal link ultimately minimeru almen establish kuran jehi fami onnani ehen kamun furtama duty of care balalair tort ganunu matikura zimma ka khilaf vi kama beleveni dawa libe faratun dawa kura farata da kunje ganuni wajibe ove e ganuni wajib ada kurumga samal kan denje farwa betumge zimma ge mingada khilaf lumashe migen eba cover kure what the standard is this breach of duty of care otimade to have a duty of care ki var straightforward mi rajyega ganuna gavada miha hisaba iru rajyega mi duty of care bayan ko fonaga namas rajyen beruge jurisdictions takuga hunnana hama mi duty of care establish kurumuge mi vara bavar ituru factor tests aru then miwagutu e daka itura karnetin namas me a brief overview of one of the latest tests namas miti arugandu mi deni to contextualize fahun rajya ganimma fegwen eto ege maane ki furtam balalama ingres vilat community kaparo test ka ei misalaka bunanyamu doctoring ebet hedet to patient ka me duty of care inde ei vara saaf kon enge kame misalakan aine me pesh adi amdung rajyega high court on establish in ihsan case ka wa bune doctor ko patient ka duty of care establish wa wagutu ves vara saaf ko kandala fove ei hospital ekga patient ek gotuga register wa hisabu e hospital kun den e hisabun farwa assign wefa doctor kun eba o kure kama duty of care then namas hunan ebba situations where it is not clear whether this person owes the other person a duty of care that the misalaka me stelco case ka ves me innani stelcoing sida dawa kura farata duty of care ebito efaratuge me not the stelco duty of because duty of care hama adi ekatse bunala duty of care is not a broad duty ingeto egemane ki libifawa gellun not e kuri amalaki a specific kamaka duty of care and zenengeta misalaka me aran kurin dek example ga me onani feng ginavege mi gosse slip vita detto then etaga mi employee employer duty of care over to ensure a safe working environment. Namavis magumatin me workplace diumga kuring outside of the employer's outside of the employer's property me onna magu e maguga misalaka vara boda vare vehiken fem bodu wegen ekam e employer onna duty of care no detto eta beruga ane wa kankan ane to make sure because eti hunnani hama e komme etan onande to state annuata egota belle veneta ehen kamu libes vida gelumekke libes egote ka gaanuni wajib bes innan jahane demba de egotun hama mi kapara test ka meenani ehen me when you're not sure whether the relationship between two parties gives rise to a duty of care kapara test establish implement cooking me in a 3 elements ki that the harm was reasonably foreseeable, that there was a relationship of proximity that is fair, just, and reasonable to impose a duty of care. Meetimi Ingres Vilatu Ganun establish kuri testing a kurim vedzam Ingres Vilatu gina situations ka duty of care impose kurani. A tort in Gabul Kurani tort log a guiding principle like a me interest protect kurang inna tive that we have me if there is space to impose a duty of care that was being done now as kapara testung kommes warakan et limit kurang wegen number 3 me introduce kofimine a numbers 1 and 2 a kurimmes hama a reasonably foreseeable the relationship of proximity me kurimmes hunna elements inga namas number 3 was the most was the one that was established by Kaparo test that it's fair, just, and reasonable to impose a duty of care. This goes to policy. That ki Kaparo test established implement pura hisabung. The claimant has to also provide policy reasons. The policy reasons to establish a duty of care. Namas me tankole me had owners kamaka vati ve rajyagaves me inani me ti මෙහරු ඉංග්‍රීසි වලතුමස් මඩ්බඩු කපාර ටෙස්ටා දුර දාකම් අදි රාජ්‍යගවෙස් මේ බෆහග කුරේ අනෙක් කවස් ෆරිවා ෆය කේස දායර් me bunaf me wani duty of care otta belumga huriha masaleka fete waki test gengulumge badaluga ege marne ki kaparo test fada test huriha masaleka tatbi kurumge badaluga approach based usule gengulung mati marhalage kortagge nimmuntaka dashu marhalage kortakunta taba wanje usula beluma eku mati marhalage kortakun nimmafawa nimmunta fandiyaruga kurmatiga masalaga tatbi kurave mimara tatbi kurave ege marne ki miharu anekaves mige kuri miwe is it fair, just, and reasonable element we are going away from that and bodang anekaves sama previous precedent adi me we have a broad and open approach kan anekaves me deveni engamu me when approaching the bar exam, it might be helpful to remember Rajyagavis Miharu if there is a negligence-based, for example, if there's a negligence-based question, and if you are asked, me veni mihaka me veni kamaka dawa of ulene heye for the manong a duty of care ebeng heye miga interpret kura iru. Remember that it is more open and approach-based now, so that egota kuriyadde enaka. Then breach of duty. The breach of duty a Haifel Construction Private Limited versus MMI Bamboo Private Limited. Miga mionani me when you are considering breach of duty ga me inani reasonable person ge standard okay. Reasonable person ge standard rajeng vani set down koffa me wani handama gotuga a maftu versus prosecutor general's office ega a peruga umtuga misalaka ingresi vilatuga reasonable person standard ki objective test ka pejjamu a the reasonable man on the Clapham omnibus namaves rajyega eba inde hama maftu PGO case ka set out koffa reasonable person na ki him mudarris ke nuata mean mi veni varaka specialized nuwe huri person ke namas the difference is a reasonable person test namas tort ka apply kurani subjective reasonable person test bala iru a breach of duty conduct kuri no breach of duty the duty breach kuri faratung e farata a situation neganwata a qualifications egga huri farata kun reasonable amaletto carry out e kuri for ege marne ki mis ayadi rajyage ehen case eggavis uphold koffa kama a armen kuriya dawarka fenna atmi case inga negligence ke on 25th July 2019 the Supreme Court issued the verdict of Ahmad Ihsan versus State A Ministry of Health, case number 2016 SCA 05. A historic first in finding a defendant liable for medical negligence. Me rajyaga mihatana hame karni me medical negligence ka me dawa kura farata ekkola nimma fa inna case mi adi Supreme Court nimma fa case mi case ka vefe gotaki dawa kura farat ke hagu dariful eru mi hadsa hingiru wani thing har after warandu wara avaha bolange barna ad apa asangat miharu arne eru Aishat yan ihsana wani tinga haruden Aishat yan ihsana eru beli andava gut tinadu regional hospital like balaf den komigote ves Aishat yan ihsana mi gentamicin kia behe mi prescribe kurani then mi base prescribe kuraru mi behe ki vara varugada behaka vegen adimige mi non side effect ka ove permanent loss of hearing nam adi namas prescribe kuri doctor mi vani Aishat yani sange weight not a barudan rangala nubala waki adadegge gentamicin prescribe koffa de hen kama vumu Aishat yani sanna vani permanently faratu ge hearing lose wefa then mi case civil court Supreme Court High Court Supreme Court ka diha arun hanagatun diha aharu fahun me successful wani then the Supreme Court reference devi me dawa kura farata ekkola nimumuga reference devi Healthcare Services Act Healthcare Professional Act then General Medical Council get doctors amal kurinje hai ethical standards asha mi huriha etsisa ka hawala difa doctor ge amal ta mi breach of duty ekkamandi mi enkamu mi ingeni mi adi maaf karwa adi mi ehen hawala devviru emme muhimu tankolaki eru e hadisa hingadiya eru adi mi ganon tavves e wujud gawa ganon evvesnu nama Supreme Court hawala dif me vani me international development of the medical profession na bala adi ganon asasige 68 pana mada bala me tatbik kureve kama ege marne ki enkamo misalaka balanya doctors aki localized profession and that the doctors me bearing kura knowledge me bearing kura technical expertise that doctors have this is muli duniyage kuriyarunta ka bala from your body of knowledge that and similarly doctors are along with that power that responsibility that they also have this duty that to adhere to international norms and international best practice and the Supreme Court has upheld that and breach of duty balair kommehen rajyega evagutu e duty misalaka sida liumun nekkamuga veenamo ves nuata sida mi nuen innaka noje gaanun ekka gavadegga mi base dinumge kuring ebe jehe balanje huriha kamaka balam mi barudama balang e huriha je sida gaanun ga nekkamuga veenamo ves niyati ehen nehediti a breach of duty ekkamar nimma for based on article 68 and arunda handamagut article 68 and the constitutional rights are it's a alustaz Ismail Vishamge lecture ga cover with hunnan items mega detail darne tas engeni misalaka hen example lege gotuga ayyo international standards of fitwa profession ekala profession negge mihen amal kudi misalaka vara simply put pilots, engineers, aeronautical engineers. These are all professions where the professional will be in compliance not just with local rules, because local rules are formed based on international best practice. That in those situations, ehmedjamu ekhala farata kun ihmal vairu evagutu sida gaanune wujudga nekkamu gavina ves me ingeni efaratun jeheni hama international development of balakan amalu pahatta then the amiga fa column bernun but I think this was already covered in the previous lecture but hama me personal injury adi me psychiatric harm of this me case ka bahure naga difa damages eba inge vara saf ko me damages aki rajyega egota limit vefa huri etchenu kanames earn fa column bernun damages naga edu although it's not in the context of tort fees and damages but me in the villa air and state a case ka vara boda limit vefa hurikan inge arnen hen damages ge foreseeability a fahu tests e bahureka then me balalari causation the causation was because this has not been vara extensively rajya kommehen cover with fire ne ehem rajya case law ek ehem namas around for completeness very vara kudu ko touch upon kollani but for test ki vara simply put mihen ne nama kihinetto vi ege mane ki misalaka balanyamu arugando me arugando me I'm on a farm. For some reason, this is my own farm. And Arun me kurakamaki gate huluala for me dani. Then diam ea hedi davaru cattle gate nukunani nukumegen hama karege kurimatsang arafa karu accident me vani. Ehem balanyam ege suwalaki arugandu e gate hulua for nubehetti nama a cattle nukunnan to e very simple eti ehama logically ves follow kure ve step edetto eti huluwa fe meanen namen eti senu nukunnan nukunname e faratun fahrege accident ves movies then e komme yagin kamake bunen nengens komes mi situation a balar accident no ana tadetto e but for test ki causation bala iru kurimas then we mean the causal link number 3 eba innan jehe kama in the fahaga kofa Hussein Rashid versus State Electronic Stelco case kangato ehem again causation was established kura me English vat ka benun kura standard me part 4 test ki then me in a novus actus interveniens ke mane ki break in the chain of causation and then me kiala din situation ga argandu gate hulu bitive cattle nukutima sida mi ane car accident nama ves aluganda misalaka prove kureven etaga misalaka CCTV cameras huri tive me ingeni ane mi faratun mion mafro dawa kura faratun mion anani maggotu wafa annamunda iru ane efarata sama var rit ko ebenge mi cattle mi kulle ka stampede kuri kienno nama sama rit ko magma tega den huriyo efaratun road safety rules and attention di fanwata Kuria balang huri nama efarata fennaneka mami varni me cattle CCTV footage unda kaguta namas evagutu hama sida efarata phone call and asking if a phone passenger seat ko again me balani ane me ko bato phone ko me ring varni to bala naga phone naga hisabu me geni naga tive efarata rangala magar nubel me efarata nenguni cattle iru a kind of break in the chain of causation. But for the phone call, if I rata fennan road ga blockage on nakamas if I rata wagutung hutemvis opportunity ebe narandu aine mikala situations there tankole ridiculous thing he become guys are balaling aspiring lawyers forum guys ebende that the ba exam prep difa huri link sama his kaves hunani because situations difa tifarata kong MCQ ga ane mi hunani choose kurang ki hinetto kong legal option netto border rangali ane ehem vasto mi kala situationally means is provide kodimo dinima ummida ki tankole fast hand naga ganna wena kama then mi onani anekaves hama kurimves dekki tortious liability ge explanation ge me duplicate sliding at hama me tiga argon for main reason to focus on damages this time damages ga mainly de HF haga kofe tort ke zimma khilafum ge sababun ehem farat kaldibunu gellun denegatum ga gellum ge duru gayakkam balanjehena kama den toti matikura gaanuni zimma ada nukurmige sababun libe gellumge farwage gotuga nagaya deveni unliquidated damages ke ka ege maane ki and I would assume everyone knows this but I will touch upon this for completeness liquidated damages ki defara detere guligen mi contract ekahal ebbasuma kam anna iru defaratun discussion na fahu decide kurave other than me breach ka breach if there is a breach this is the amount of damages that one party shall owe the other party kama a liquidated damages ege opposite ege converse rather in this situation unliquidated damages it's not an amount that has been agreed by parties this tortious liability arise wakam gaveja ege marne ki damage prove vedze breach duty of care prove vedze breach become prove vedze damage prove vedze causal link was prove vedze hisabun ebeje hedatto remedy egotuga medeni damages de iru e balani sida efarata vefahuri gellume adi balafa the intent of the damages will be to return the claimant to the position they would have been in had the tort not taken place ebbafaru me vara clear cut etse and ebbafaru me eha clear cut nuan e misalaka me efaratun vi kamaki hame karni me vara minor injury the minor injury again it is not lifetime akadana kama visno namas injury medical expenses arise varne medical expenses arise vefa adi evagutu kolu masekkatanu devenya masekkatanu da loss of economic loss to ekahala it's a fasa naga devidane namas ihsan case kavi for that if somebody loses their hearing hisabun bara undagu andetta fully gauge kurang kihinetto me damages award kuran there will be factor tests in other jurisdictions to a certain extent namas adiya rajyakwe fully en hsn ihsan gavis but a high amounting award could deva for any in the millions or even if for psychiatric damage as well but that is now been codified as that has now been set out in the Supreme Court me judgment as well that it will be unliquidated damages and upon first considering remoteness of damage then a mihatana negligence ke around me ane buna dakkan hori wahake ki negligence a goligen evis Faratege sualen horizamo, you can write it in chat me wagutu. But just neti nuniamung unmute kollafis ahalang, and preferably chatting could again gosla nengeta with a defamation no. Defamation ge elements was mean any Rajega set out of Rajega, if you know the historical development Rajega Abura Behumge Ganuneng asa Aneka was a Ganun Walevigendie Enkamo Miharu. This is it's not a right protected in by statute any longer, but it is still a tort. Enkamo Abura Behumge Rukunta mihunani kandala mi furtama meenani abura behumge bas be meenani abu e bahuga dawa kura miha hawala difa otu e bas shair kurun e bahuga sababun dawa kura miha ya gellume meduerivu dawa kura miha ki abura behumge dawa e kota husharumge haisiyatu e mihe kamago min kommeru kunaka balalar furtama abura behumge bas Abura Behumge bas has to be it is an untrue statement. Untrue statement that you're making anemmiha a commerce varige derakame dinuma misalakan engamu amugotegga afro augurana govun kahala kankan included nuan abura behumugen ei hamasida buna dimala buna etc. That names abura behumaki mihun tere mujtamao terega anemihage agu pattalan kala gotaka buna dogu malumataka wang ebajehe then devane mionani e dawa kura miha hawala default engama misalakan ane me amugotegga me opinion en wadante to me wariginang urabe furnace events kannege namas lawyers are liars de bone tade to ei vedane opinion na namas eti ekahal situation ga wakimi haka hawala di fenwate nedden hawala di dinume bunair it does not have to be specifically anemihage nambuna kannuje hengeto emihe ei emiha kan ದೇಹವಣಿಕೊವ್ವೆಸ್ ಎ ಎಮಿಹಕ ಹವಾಲಾ ದಿನುಂ ಕಮ ಬೆಲೆವೇಣೆ ಎದೆನ್ ಬಲ ಅದಿ ದೇಹವುಮೆ ಬುಣಾರ್ ದೇಹವುಮ್ಮಿ ಗೇಜ್ ಕುರಣಿ ಹಮ ಸಬುಬರಿ ಇನ್ಸಾನೆಗೆ ನೋತ ರೀಸನಬಲ್ ಪರ್ಸನ್ನೆಗೆ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಎಹೆಂ ಬಲಾಫ ರೀಸನಬಲ್ ಪರ್ಸನ್ ನಕಂ ಎ ಬುಣಾ ಬುಣುಮಕಿ ಎಮಿಮಿಹಕ ನಿಸ್ಪೆಕ್ ಬುಣಿ ಎಚ್ಚಕೆ ಎಕನ್ ದೇಹವನ್ಯಾಮು ಎಯಿ ದೇವನ ರೂಪಂವೆಸ್ ಫುರಿ ಹಮ ವೆಫಮಿ ಒನ್ನನಿ then timmane e bas shair kuran jehene e publish kuran jehene wakenge to publish ki kommehen officially newspaper ega me chaapu kurumennun it has to be me amun terega buneve bahaka wan jehene misalakan alugandu miyadu mihin notebook nagagen alugandu ekanima ekani inde liya note fote getchel liuni tiye ei kitamme dogu malumatakas kitamme abura defamatory statement ka vi kamuga yes evves farataka e notebook access niinde ei mihun terega nispeva mihage agu wattala amala kannuwa ha hindaku eti publish kuri kama kannuwa ne tadetta then hataruwane meenani e bahuge sababun dawa kura mihaya gellume medwerivo then mige mane ki misalakan migen eba jehe sida gellumewa misalakan alugandu mi bunaniya alugandu vara kamuda mi restaurant if for some reason the alugandu gossa mi bunani alugandu rattisse kariga me etam bandu koffe mi haruwani ehme mi vara dera kameke ehme veta kanu deve den ekama hedi mihun hi kurani mi komhen alugonda kam mihem mi punani mi alugonda kamunuda kayachal dibigen arun beenun honiya mihun den etana ta ehme alu rattisse kari bunegen e ratti den e friend fahun handane nemmi wahaken ehen kamu restaurant kan aslo evis gellumennu etadetto alugondu ehen dogu malumat spread kogen names misalaka contrast it with an example where alugondu apparently I am running a very famous food critic blog then a blog ehen jehi tive vara bavaru mihun nan et reach again vara bavaru mihun restaurant dium huttali because they thought it was no longer in business no tarundu that dogu review di again hama ehem mi wani ehem medje amun vara saaf kon e bove de to gellume besli bifa e gelluma ki economic loss of profit then me only number 5 dawa kura miha ki abura behumge dawa e kota hushalumge haisiyat e miha kapmu mi after that miya balairu me ki gagandaka huriha emena ves access ek kame a private individuals of Vinamgavis, legal entities such as companies, NGOs, everyone has the right to take it to court. Now, this is limited in the case of the state. Daulatuge abura behigen court addium a hulwalef a comment no. Then abura behumuge me defenses. Abra behumge difaw takuga mihunani ekamaki tedu hagigatekkan sabit kodino number 1 naki emme mashhur not emme rangalu defense misalaka aluganda bune vidane hama wara mi anemiha ene ei kuriduwahu me amara ehemmes edaw ehen algonda a defamatory statement punavidan if I can prove that it is true very difficult one but if I can prove that it is true e hisabon e abura behon kamaka hamanuan devaniki me imtiyaz libigenwa magamegga hure dekki wahakekavvu ಕಾನೂನು ಹುದ್ದಕೊಫಾವ ಮಾಗಾಮೆಗ ದೆಕ್ಕಿ ವಾಹಕೆ ಕವ್ವು ಆಮು ಮಸ್ಲಹತಟ್ಟಕ ದೆಕ್ಕಿ ವಾಹಕೆ ಕಮವು ತೆದುವೆರಿ ಕಮಾಯಕು ಫಾಳ್ಕುರಿ ರವಿಯುವ ಕಮವು ನುಬෑ ನಿಯತೆ ನೆತಿ ಶಾಯರ್ಕುರಿ ಎಚ್ಚೆ ಕಮಬ್ಬುನೆ ಮಾಫಂ ಎದು ei furihama difawenu to ege ma mide emme fahudeechaki furihama difawenu ege maaneki these are partial defenses I'm sure all of you will know again me how they work so I will not be touching upon that further unless asked otherwise then mafa eduma fahu liyavunuku islahu kuru ei furihama difawenu this is me kuravunuku islahu kuru meet this will count more in the cases of libel a libel ga me reprint not apologies issue ko for retract kurun not reprint kurun ege maaneki then aburge then in slide balala iru libel and slander this is very simply put libel lucky defamatory statement made in writing or published in newspapers tweets slander is a defamatory statement that is made orally. They are included in general defenses of tort. Ingata voluntary non-fit injuria. Me Latin phrase ga translation ki to one who volunteers no harm is done. Egemane ki think me ge bende think tafatu element me ves kurimis bona kurim fa kolbehen meets me sida divehi ganunu naga fritz sanum this is me UK jurisdiction no naga fame but vara kurugotaka me alwala narun running him mean komme element ges multiple ituru me hama test hure namas me haru e huriha detail laka diumang earning him time was not my higa algondu me hisaba me vara kudukot touch upon kollani so the furthermore me onnani voluntary and freely made there were an agreement either express or implied and third knowledge of nature and extent which is a subjective test so misalakam arne me voluntary and freely made ga amugotegga me kudukod me misa full defense aron furtama explain kolla then angeto in an example context ege mane ki misalaka me onnani bridge ingeta bridge ge medugo e section ekkom mioti hama halak wefa then mitakuen arne hama eggutkes karuga duwa fogosia mo hama bridgeun bette ingeto enun gote negota community then me before that eba inde hama government me ropes damafa rope please turn back collapsed bridge ahead egota ves huriha me notices hama rangala kiyan inge egota bodu ko jahafa ehisabun then Mionani Namas me Jahafa Huttasvis, it is not very visible come commerce inge than this for argument's sake. The person who is driving the me car has heard on the radio another time or has heard somehow that this bridge has collapsed. Then me despite knowing this, Mimi Dani Hama me Duvafa Sida Korea goes then Karu vetting injuries vegging. They are bringing a claim in negligence saying me bridge collapse for this notice Jahafur and notice Rangalaka Nenge, so the statutory duty to ensure road safety was not complied with. Ekala negligence case then me Anekkolum dawalli befaratu mires kura defense ki voluntary non-fit injury. Egamaniaki dawa kura faratu voluntarily and freely emikan kuri a karu duvvi eta ekola mi anenghen bridge hal aku fovavis karu duvvi amila ihtiyarunne. Then devarne any agreement either express or implied. Me hama rajya contract ganuna belias was earning hang defaratu demedorna ebbas woma ki komehen me liumung organization no agapohomes oveve ehem me gave sama me situation ga minani implied or express very simple in situations of employment gami defense naganama. A contractual writing is sufficient, but implied you can imply it from the actions. That the egota me arun kurin demong example ga a car driver nos dawa kura faratun ka duvikama kives actions eba they have it again reasonable person test eba they have me that me faratun except kurakan can you explain the current law with regard to elements of tort? Is it 3 without establishing of element of duty of care, or is establishing duty of care a required element? Asking because most textbooks mentions 4 elements with first element having tests. Okay. Local standard balala I'll go back to the example element of tort. See, the thing is the 4 elements that you're discussing, that is duty of care and breach of duty of care, those are combined into one element in this local context, but when it comes to the factor tests, it is further elaborated. For example, mainly so this is the latest. I'll go back to it. I'll close the chatting though because it's getting in the way. Yeah, so this is the Ibrahim Latif and Amanat Shahida case. So this is also referenced in the new Stelco case. Stelco case Hassan case, Shahida case, a high-fall construction case. The 3 cases are referenced. Stelco case mean any full overview Nagadif on what the current tort regime is. So for tort, it is these 3 elements. That is fault, damage, and causal link. Nota Sheltiganengamale Gelong adi e amala inna a guru sababi guru. So that is also reflected in Hussein Rashid and State Electric Company Limited, but in a different sort of language. and this is for negligence specifically. It's reflected in a different language. Me tort ke 3 elements. So if you look at number 1, it says Ganunu Matikura Amalaka Khilaf Vumuge Amal. So that is, if you look at it, that is the first 2 elements that are usually referred to in the textbooks. Misalaka me Ganunu Matikura Amalaki, Ganunu Matikura Wajiben Asl, that should be, I think. Ganunu Matikura Wajibaki, duty of care. Then Ea Hilaf Vumuge Amalaki, the breach of duty of care. Engamu fault me local context we refer to it as fault, but that is a 2-pronged test which has to include duty of care and the breach of duty of care. That is how you can establish fault, and it is what has been done. Mega specifically a hataru element gotang include nukuri, because this is the new case and it covers this specifically. But me high court gaves me establish in ihsan judgment gaves in the a hataru element gotaves a bayango for in the case of medical negligence and negligence. But so I hope that makes it clear. 4 elements in there, but it is implied as one in the. Okay, thank you, clear now. All right, I'll stop. Okay, and I will go back with the Yamung to where we were. General defenses of tort. Mega thing I'm quoting the example ga karuduvang in dawa kura faratung bridge ka mi duvvali kang inge to duvvali thive eba inge efaratu ge actions un eba dehave sababveri insanege mi minganum bala iru. There is an implied agreement kang that they know that there is a collapse bridge. Then that means a timmana element, knowledge of nature and extent. The me was hama subjective test inge to mege maaneki me tankole me hisaba miti aslo difficult me varni eyadi berugam takuga. This is taken in ehen context alon kiyal dena a misalaka in an example where the claimant mihiri rangala kiketa burani. The defendant is not in a good state because they've taken, let's say, alcohol. A situation ga ena a huri halatuga eneka full knowledge and nekama mivani a nature extent and appreciate nukureveti because he is operating under limited mental faculties. That the egota inna tiveves. So it is that subjective namas rajega context. I'm assuming that would not be an issue. Me has not been local context me factors are actually set out ko but these are the 3 elements that need to be satisfied when you are when the defendant is raising the claim of voluntary non-fit injuria. So saying that the other person has essentially it is saying that you've consented to this happening because you've agreed okay, while knowing that this is what is what you are risking. A me defense aki then me contributory negligence ke defense and kave sama bonangoti mi ves ha bodakang in detail explain koddi fe nete in local context. Then contributory negligence ki usually a partial defense to contribute in foreign jurisdictions. Contributory negligence OTT the defendant who committed the original tort of negligence does not get away completely, but rather hisabon costs a portion kurani. Costs a portion kurunge marne ki costs a portion kurunge marne ki me dakkang me jehe gellumge adada adi me court dieti award kura me fee wakilunge fee me kahala costs ta vesunanta ehingam ta me separate kura etsa bative. It's a portion kuran egemarne ki misalakang ane arund me duvani me kare duvva fadairu traffic light meenani halaku if traffic light halaku if inna thive alugandu me alugandu kannenge aslu miyo accident ವಾಂಗುಳುನಸ್ ಇದಂಗೆನ್ ತೈಗುತ ಹಮ ಅಣೆಕ್ಕೊಳುಂ ವೆಸ್ ಮಿ ಅಣ್ಣ ಕಾರಕ ವೆಸ್ if me three assuming this is a three-way traffic light if arataka ves rangalaka hama work no kurati no fenige then me fong accident me wani nama ves alugandu huri evagutu seat belt nala ehem vedze yamun ane alugandu demmi dawwa mi kurani jointly against the state, the council, whichever was responsible for maintaining the traffic light, and the other car, because a car was me speed kuramano. They farata joint and severally liable kuramage. I'm going to action me genani. And they farata ges negligence hediye. Aluganda me accident me harma if me damages. If damage if farata damages pay kuramage. Namas if farata ko me naga minaga defense ki contributory negligence aluganda aslu miha me aluganda aslu miha bada me injury vi komme henne accident ka hediye nune but a accident vi iru aluganda seat belt nala hurime ehme furtama ehme eti establish kuran them me burden of proof me shift 20 defendant I'm not sure I mentioned this in the beginning but in cases of tort komme element prove kuruma kives claimant ke duty so the duty of proof rests on the claimant in cases of tort and but this where of course where you're raising defenses the burden of proof shifts to the defendant and the defendant has to demonstrate for the manner that the claimant failed to take proper care in the circumstances for their own safety and the failure to take care was a contributory cause of the damage suffered. It does not have to be the only cause of the damage suffered. It has to contribute to the fact. If it says it was a cause of the damage suffered, prove me accident speeding if aratun seat belt nala hurime ekambi ei komme prove kodden je kamenno you just have to prove that it contributes to the situation anen hen me itura gosvi mi hemme kenne ei miga me require me pura element aki then me onani employer's liability or vicarious liability in the alugandu detige vara kuda distinction furtamanu denam because on the face of it might appear the same ege tafataki employer's liability ki wazifa de faratun wazifa ada kura farata onna liability ege mane ki wazifa ada kura farata nisbekkom misalaka ihmaluge amale hinga fiyamun wazifa de faratun ekaman naganje hezimma ei employer's liability the liability you have to your employee ingeto in contrast vicarious liability the liability you have for your employee ege marne ki wazifa ada kura faratun wazifa ada kura faratun mi ihmaluge amale kuriya gengo siyamu ekama wazifa de faratun naganje hezimma etafatu huriya befuna besafto employer's liability or vicarious liability etafatu arun balani saf kamang unless I get an indication otherwise so employer's liability or balalana employer's liability or balal furtamanu kurimes arun me fetti arun denu hen ane me huriha madani go haki tort enno enkam obviously employees have several causes of action against an employer civil misalaka contractual dispute tetto wazifa en kandaluma mikahal kankam abbes hama a cause of action ta denge bahure breach of statutory duty rajyega vedzeyamu wazifa behe ganun a ganun number de oblique has ashe egen eba inde section 75 ge dashun vara varang arne vara vara broad and extensive rights. The for misalakan eheng gaumtako ga amuko nuhunha varang ebetehe when you are ensuring the right to work, the right to a safe working environment, a rights the Section 75 ga hure encapsulate koffa and adi inde eheng me wazifa ada kurata ga ekahala me injury vejam a medical expenses of this responsible ones hai kande meti argon potentially a tort mita jaha for me reason ki breach of statutory duty is also a tort or me presentation na kuen e cover no kurang but kurimis enehen sood ge just a sood ge fotuga ves explain kodde breach of statutory duty as a tort aki koshetto it is essentially where قانونكم ما تكون واجبة خلاف نوني الزام إيه خلاف وجن مي دماغ مدني جوهكا قولي مدني جوهكا قولي دوا أفلم جه حقو قانون جد أشون كمهن exclude نكون نمس إهن إجن إهم penalty كندارلا فرنتيامو a breach of statutory duty أهدي بس هم tort كدوا أفلم كمان ميونني so section 75 ge dashum ves mi dawa kureven aning hen sida remedy and net kamga vetse yamu wazifa de farata ka tort ge dawa ves ufulan dem mi onnani negligence ke mi furi hama kuranje rukun takaki hama the previously almen cover mi hatanam mi kuri mi hatanam mi cover kuri elements mi onnani hama cover kura then me only vicarious liability. Inge to vicarious liability ga me only meet me rajya gaves actually me establish vefa onna kame. Rajya me vicarious liability is when an employer bears strict liability for the wrongdoings of the employee. Egamane ki kommeheng me ga me maka wazifa ada kura faratum e amalu kuriya gengos fa warnama wazifa de faratung e hama responsible wanje he kala gotaka me kam me onnani ehen kamun me the private employers are public employers is of course tafat wandato arun kuring explain kodin supreme court case Ahmad Ihsan versus state etiga me aslu negligent vefa a barudan a patient ke weight check no kommi onnani doctor ta that kommehen me doctor employ kura hospital visnung a hospital lung adi hospital a mandate me folwani ministry of health ke dasha vairu ekamukuves me hama dawlata de kola gene for dawlata de kola nimma fa case me enkamun ebe inge me public sector ga work kuren mun government office ge employee wrongdoing a coffee am not me tortious act a coffee among if the claimant can bring the claim against the employing state entity then many private employers Ahmad Muhammad Musa versus Wataniya Telecom Maldives me get explanation of this deva finan is justice sudke photo where the claimant property was damaged because of some I think internaing or anikete kuran gaim established kuran and hedi the contractor would have to be responsible. Then vicarious liability and elements that have to be that have to be complied. These elements have not been explored much in the Maldivian context. And because this is not in the Maldivian context, but of course, main comment check some factor tests the first two are very simple. The employment relationship established kurang. This will be mostly employment law based, so it is slightly outside the scope of this lecture. But employee gota balarne hama even if the rajya laws kaina gota veja employee kama balarne me employment agreement sida liumun nekkamuga vinama ves arne varagina situations ga rajyaga when it comes to employment law usually the courts do infer an employment relationship that exists between the parties and etiga employment relationship nuhunna kama vara madu situations ka mihunani temporary workers casual me workers that go for hama vara short term contracts, but even in those situations we have a general regulation of employment in gotum there is more room to imply that hama if you're carrying out the duties that normally an employee would carry out, you are considered an employee, there mean any commission of a tort by the employee, then a commission of a tort, a tort, a key coach, it can be any action that it doesn't necessarily have to be negligence. That some examples of torts, but it can be any of the 27 or further torts really. The mean any tort must be committed during employment. Me difficult element perutantaga establish kurang because it's a two-pronged test. It is either during employment me mean kurani kommeheng wazifa ge gadiga kurikamavura boda wazifa in relation to their duties amalaki an unauthorized way of doing an authorized act kala a types of tests mihunani e misalaka bunanyamu alugandu aine me aluganda me very bear with me me very ridiculous example, but I hope this will clear it up a little. Aluganda ki me restaurant get me marketing in charging, and then the arrogant duty includes me to make sure that this restaurant gets as many customers as possible. But recently in the last month me down the road our restaurant huluwagen and me our restaurant huluwagen alugandu me kiketa bonani a restaurant hedi arunge me restaurant hum evvis varaka business libele maduwan fetti එහෙම අල්ගන් මේ පුරාකමකි මේ private account හුළුවෑගෙන් අනෙ restaurant බෙහෙගොතුන් defamatory statements publish kuram fetti as we've checked in the previous slides. Hama defamation is a tort and me gota this is libel or slander that they gota around hama me tweet kurani ane restaurant ke vara khasi sakarate badige mida ule මිහෙන් ට්වීට් කුරා වරක එතන මිහුන් දාලා මදුවගේ අරුන්ගේ restaurant එකකින මිහුන් යන්නේ ඒ හිසාබුන් can the restaurant owners of where I work will they be responsible for my tort of defamation? ඒ හිසාබුන් yes බුරන්ජෙන්ද on the face of it because it's an unauthorized way gutkavis arun kar arunge employer nubune aning him fake account and hatagging abur ani restaurant ke abura peheshke namaves arun ekam kuri to for the purpose of actually what I was employed for, to promote my restaurant and to make sure that my restaurant gets more business. Must be committed during employment. It does not mean alugandu negligently kame kuraniye muling ehen kamakaguligen just during the employment time. Commissarige employer control me element ka inna kamang aslu edakani. But again, this has not been entirely elaborated in Moldavian law. Then I understand that I understand that syllabus bala it doesn't cover a lot of me because as I think even also as Visham mentioned in his presentation, that there really isn't too many factor tests that are in outside jurisdictions, but as long as you understand the basic elements mean because I will refer kuri bar exam prep ge link mes it is very in any scenario edifa then a scenario ga me inna it's a kaguligen aha swala ge any potential answers which you have to choose from that egota me we have as me try kuri me to carry out kuram with examples so that you understand how to apply each of those which I'm sure IRAC exams you must have done in school and egotan emme border rajaga miharu huri etsaki me negligence and general tort abehegotan huri and for anyone that because I note the number of participants have increased from when I started adi affaru repeat kollanam just in case anyone didn't hear it then but me cases are all obviously available on the relevant me websites of the relevant courts but for for a more comprehensive overview of the case law radzega huri mihatana develop for huri on tort law you can go me justice sudge website and hure ham me for the published and this is obviously not just for tort law because I understand that the syllabus covers me Babaruehing areas and fields of law. So there are other textbooks, all textbooks that have been published thus far are available. So please try and use all the resources you have at your disposal. If any of you have missed mihatana nagadi for this lecture, mihatana attend nuin what them Korean lectures attend nui kam gavana sama. We had to get recordings available one at all times and hamabadifa it's on check cooking could again there when get slides was available one but there's not there which is being located currently and will be updated shortly in the next week and are going to get me but if there is any further question about the topics you can me email as well earning ituru clarification because that would be and that would be a better way I'm going to thank me detailed answer to whatever question or doubt that you have. Then elements of tort, negligence, defamation, general defenses, employers liability are going to cover then breach of statutory duty goes. As I mentioned, it'll be covered in the books. Nuisance, I believe, has been covered. And then strict liability, economy had to cover any. Then just I'll write it in the chat, the email as well. So you can ask me question. Then we will go to urgent swal and etiamong alugandu ves pakivela nengeto. I'll wait a minute for anyone to type their questions if they have any. Ebang me Swale, I believe you mentioned bar prep model questions. Where can I find them? There's me aspiring lawyers. I don't think would have a forum aspiring lawyers forum ga uluva kame me aspiring lawyers forum ki teams ga in open platform ea huriha me hama students with law students lawyers anyone can me register. Inge to register one link in and if you go to the bar council website and bar council ga bar exam tab what if a by exam tab of it of theory scroll kura updates and queries sign up for the aspiring lawyers forum using this link. Sign up koldima, you will receive you don't see the link madukola but me huluala I will share my screening so that it's easier. Aspiring lawyers register in general go huri habbe furna fenna gotang ebang it's a general guidance on the preparation for the exam and the post go far ganda even madukola vechengada and share kollana. Please bear with me while this loads. The MCQ format and style. It's posted on 31st. Link code. Yeah, thank you, Marco. Sorry, me phone me to the chat. Thank you. Oh, I want to phone question ehibe fly walking Marco. Yeah. And the preparation link eves egemes hama me eging tankola bodang I think would have been certain soft one kannenge konkala structures and it's just that then this was posted on the forum link. I apologize if you can't see it, but yeah, either then please feel free to send me an email or everything and then I will clarify it to the best of my ability. Since I didn't get any other questions in that time, I will take break. Thank you everyone for attending it. See you. And good luck for the by exam.